Thank you, Lisa, and good morning to everybody who is joining us today. Today, we are going to be talking about restraint clauses. So, drafting ironclad restraints and navigating the pitfalls of restraint of trade clauses. Now, today we're going to cover quite a bit, looking at what the paper and this session is going to cover. We're going to look at restraint of trade clauses in different contexts, and this is really looking at protecting business interests or protecting legitimate protectable interests, which is critical when you are acting for the person whose interests they are. And there are significant drafting challenges that can pop up, particularly depending on which jurisdiction you are in. Now, the ABS, the Australian Bureau of Statistics, has reported that nearly 47% of businesses include these types of clauses in employment contracts, and there's no limitation at the moment on the types of people who this can apply to. So we're going to have a look at the importance of precise and effective drafting, because that is going to be critical a lot of the time to being able to protect your client's interests. We're going to have a look at the three main types of restraint clauses. So looking at non-compete clauses, non-solicitation clauses, and non-disclosure or clauses that protect confidential information. We're going to have a look at rebutting the presumption of unenforceability and looking at the jurisdictions in which this might apply, both outside Australia and also across Australian states and territories. And then we're going to have a look at some of the things that play into this concept of reasonableness when we're drafting restraint of clauses generally, as well as some of the specific considerations when we're drafting restraints in an employment law context. And that's particularly important when you look at the inequality of bargaining power that very often exists, particularly for junior employees or people who might be on an award, people who are just starting their career, and the inequality of bargaining power that might arise in those types of situations. We'll look at specific considerations when drafting restraints in an employment law context versus a business transaction context or a negotiation between parties with respect to equity and other types of scenarios. And then we're going to have a look at what people refer to as the waterfall or cascading style of restraint of trade clauses. We're going to consider some of the things that are really important in tailoring a restraint of trade clause for particular facts and circumstances, because the whole concept of whether or not a clause or a restraint is reasonable is going to depend on why it's there in the first place and being able to explain the justification for it. And then having a look at some recent decisions and some lessons that we can learn from those. So first of all, let's have a look at the three main types of restraint. The first is a non-compete restraint. So once you leave a particular business, the person who is being restrained from activities that would involve them with a competing business or from setting up their own business in competition with the organisation that they have just left, whether that's because they've sold that business or they've left their employment. And it's often with respect to certain geographical areas or particular types of business activities. Looking at non-solicitation restraints. So looking at the powers that would preclude somebody from soliciting, enticing, cajoling, approaching, or dealing with people who are involved in that former business. So whether they are the former employee or the business that they have just sold. And those are approaches to staff members, clients, suppliers, sometimes key suppliers are very much subject to the influence of the person who is now left the organisation, and other types of things that that person could otherwise seek to leverage to the disadvantage of the business that is trying to protect its interests. And then we'll have a look at non-disclosure clauses. So the things that would restrict particularly former workers, but also sometimes well, a lot of the time actually, former owners from disclosing confidential information to somebody who could use it to their advantage in competition with the former business. And this can include, it doesn't actually have to necessarily be intellectual property from the perspective of a legal protectable right. It could be trade secrets, know-how, client lists, other types of information that may not necessarily be a patent or other type of formal recognition of intellectual property, but things that are nevertheless of value to the business that has just parted ways with the person that is sought to be restrained. So let's get started. From a basic policy perspective, and if we take a step back of looking, before we jump into the law, the starting position is that competition is a good thing. It helps the market. It makes it more efficient. It is better for consumers. It is better for the economy when competition is robust and people are able to compete against each other. So the starting position from a policy perspective is that a restraint of trade is void and unenforceable unless it's reasonably necessary to protect the legitimate business interests of the person that is seeking that protection. Now, the law that governs this area is relatively complex, and there are growing calls for reform that we're about to have a look at, both in Australia and in other comparable jurisdictions, but not all comparable jurisdictions. And Australia is a bit of an outlier in the Southeast Asian area of the world in which we're often operating. So having a look at the fact that there aren't similar reforms being called for in places like Singapore or Hong Kong, which is a lot of the time where cross-border transactions might be occurring or competition for talent might be emerging. But the common law has long recognised the need to strike a fair balance between the freedom of contract and public interest in competition. Particularly in a business sale context, a restraint might be considered as a reasonable mechanism that is necessary to protect the goodwill that is subject of that sale transaction. I'm about to hand you $1 bajillion for a business that I see value in, but if you walk out the door and set up next door to me and start up something that is directly in conflict or in direct competition with that business, I'm handing over my money and seeing the value literally walk out the door. So looking at that protection of goodwill, and we'll talk about goodwill a little bit later, that is subject of the sale transaction and that has value attached to it in a business sale transaction or another type of transaction. In an employment context, we've already just started to touch on the inherent inequality of relative bargaining power between employers and employees. And that really seems to be the driver for the calls for reform in other jurisdictions. So let's have a look at those now. Okay, so very recently, only last year, the United States Federal Trade Commission announced a blanket ban on non-compete clauses. Now, there are states in the US that have already banned restraint clauses. So the state of California is one that has already had a ban in place for restraints of trade in particular circumstances. But the Federal Trade Commission in the states announced a blanket ban on non-compete clauses in the employment context with a couple of exceptions. So the rule applies retrospectively, and it also provides that existing non-compete clauses will become unenforceable 120 days after the ban came into effect. Now, there are exceptions to the ban. So if we're talking about senior executives, and those are defined as people who are making more than $151,164 a year in what's referred to as policy-making positions. So people who have the ability to influence what the company does, the types of decisions that it makes, those types of things, although there hasn't been a huge amount of commentary on what is or is not a policy-making position yet. Now, the new rules don't affect non-compete arrangements between franchisors or franchisees, and they also don't affect non-competes related to the sale of business. Now, this is following a similar or comparable announcement in the UK of a proposal that it made in May 2023 to impose a statutory limit on the duration of non-competes to lower that to 3 months. Again, this is not something that has been considered in the business sale context, but really appears to be trying to address that inequality of bargaining power between people who might be coming in at entry-level positions or people who are in lower paid employment arrangements who really don't have any kind of effective bargaining power when they are entering into an employment contract with the employer. So how does that affect what is being proposed in Australia? Because in April 2024 as well, the Australian Government's Competition Review Task Force released an issues paper, which is Working Future, the Australian Government's white paper on jobs and opportunities. Now, that paper relies very heavily on data that has been sourced from the Australian Bureau of Statistics that concerns the proliferation of post-employment restraints by Australian businesses on their employees. It talks about the very high percentage, so that 47% of businesses including these types of clauses in employment contracts, and that's across the board. So whether you are an entry-level graduate level position, or somebody who might be on an award, or somebody who is engaged in not a particularly senior position within the organisation, but still has restraints put on them within their employment contract arrangements. Now, the review from the task force is set out to undertake policy projects and provide advice to the government on how to improve competition across the economy. And so it has identified several issues relating to the use and the impact, or what it says is the impact of non-compete clauses and how common they are. So it describes a chilling effect of restraint clauses on worker mobility, particularly among lower income workers, to choose better paying jobs because they might be worried about a restraint of trade being enforced against them. High cost of litigation. I think everybody who is participating in this workshop will be familiar with how much that can entail. The lack of clear guidance and the use of cascading clauses. We'll talk about cascading clauses in a minute. And what it describes as the economic consequences of potentially inefficient allocation of labour and information, which could be hampering productivity and innovation. Now, it is worth noting that the issues paper appears to be drawing its conclusions based on the ABS data rather than other independent studies. And it suggests a causal link between the use of the restraints and that lack of labour mobility, or what it describes as a lack of labour mobility. But it doesn't present, or at least it doesn't describe, any evidence in support of that hypothesis. So the use of restraints has resulted in lower labour mobility. The two things appear to be correlating based on the ABS data, but there hasn't been any kind of evidence presented to say that one is the root cause of the other. So that is yet to be tested, and there doesn't appear at this stage to be much evidence in Australia the UK or none of the issues papers that have emerged in Australia, the UK, or the US describe studies or evidence that draw that connection between cause and effect. Now, the issues paper for in Australia similarly is focused on employment clauses or labour mobility rather than looking at restraints in the context of a business sale or a business transaction more generally. So let's have a look at some of the differences across Australian jurisdictions. Because in Australia, the interpretation of restraint of trade clauses is seen to be most flexible in my home state, which is New South Wales, and that is thanks to the operation of our Restraint of Trade 1976 State Act. Now, that the operation of that Act, in particular Section 4 of the Act, provides our Supreme Court with the power to read down restraint clauses to give effect to the restraint if it is seen to be reasonably protecting legitimate protectable interests. In those sorts of scenarios, it's possible for, if the court has concluded that the restraint clause is for a legitimate purpose, but it's currently inconsistent with public policy, just the way that it's been drafted, then the court can read down that clause so that it is consistent with public policy. So it can make changes to the drafting, it can adjust certain things within a restraint clause to make it fit. Other Australian states and territories don't have that same level of flexibility. So in New South Wales, they can make adjustments to do that, but in other states, the court is able to use its powers as contemplated under the common law to sever a part of a restraint clause that is offensive, where it's possible for that offending part, and only that offending part, to be literally taken out. It's referred to as the blue pencil test. If I draw a line through the part that I don't like, will the rest of, or the balance of that clause operate unchanged? Will its meaning be unchanged? Or do I need to rewrite any part of the clause, in which case the whole thing falls apart? But what we will see is that when we're looking at a restraint of trade clause, for example, in Victoria, the ACT, anywhere other than New South Wales, restraint clauses are drafted with this concept of a cascading or a waterfall style of drafting, so that if something is seen to be way too onerous, so a 5-year restraint is held to be way too onerous for somebody in an employment contract, the next level down will be a 3-year clause, a 3-year restraint, or a 1-year restraint, or a 6-month restraint, because in drafting it that way, the court would be able to just sever the part that it sees as being too onerous and against public policy without needing to amend the rest of the clause. So let's have a look at some of the considerations that we need to have, not just in relation to our waterfall style of drafting, but the types of things that we need to be asking ourselves when we are actually drafting a restraint clause. And sometimes you will need to take a step back from what is often just a boilerplate clause. It's always used. This is just what we do, but it is good practice, particularly if you want a restraint to be enforceable, and particularly if this is somebody who is really important to the business and the value of the business, that we're actually turning our minds to what we're trying to achieve with the restraint. So looking at this from an enforceability perspective, the general test is that the restraint has to seek to protect a legitimate protectable interest of the employer and be no more than is reasonable for the protection of that interest. So what is a legitimate protectable interest? A A protectable interest might be something that is considered an asset by the company. This is probably the easiest way to look at things. So looking at goodwill within a business, customer connections, customer lists, client lists, customer information, are all assets that are considered to be legitimate protectable interests. Trade secrets or confidential information. What's the secret sauce that makes this business really valuable to anyone? Is it that we do things a particular way? Is it that we've got a really efficient process? Is it that we've got a system set up within our back office that makes us really able to operate effectively? Is it the way we train our staff? Is it the way that we deal with clients? Is it that we have particular provisions in our contracts with clients that makes it easier to deal with us or harder to not deal with us? What is our staff retention like? Do we really rely heavily on particular people within an organisation? And then the second limb of it is what is actually considered to be reasonable. And from an enforceability perspective, reasonableness is something that is no more than is reasonably necessary to protect a legitimate protectable interest. So, some of the specific considerations in an employment context, when we're looking to assess whether or not a clause is reasonable and enforceable, is considering things like what we've got up here on the screen right now. So the timing, how long are we seeking to restrain or prevent certain types of conduct from that person or the party involved? The geographical reach. Am I trying to ban somebody from doing something worldwide versus doing something in a particular postcode or a particular city or a particular state? What are the reasons for that? Am I a business that's only operating in the ACT, but I'm seeking to restrain any kind of competition across the country or in the Southern Hemisphere, for example? What are the types of activities that I'm trying to restrain the other person from doing? Am I trying to restrain them from earning a living using their qualifications, even though they might be doing that they might be using their skills in a business that is not in direct competition with my business? Is that reasonable? How are they going to pay the rent? The nature of the industry is also important. So the types of value that is attributed to the personal relationships in that industry. If you've got somebody who is the client coordinator for a business that relies very heavily on personal relationships, that might be a service industry is a good example. So that could be anything from law to personal training to logistics, the types of things that are really heavily dependent on people who might be perceived as gatekeepers or facilitators for that relationship to exist and the success of the business that relies on those relationships. Looking at the seniority of the person who is sought to be restrained, so their business connections, or somebody who is literally the face of the business, the person whose image is all over the website, who is the personal driver behind a business. Looking at confidential information, so who has confidential information, and if they have it, does it have commercial value attributed to it? Is it going to be worth something to a competitor? And if so, what is the nature of that information, and how long would it reasonably considered to be valuable for? Influence is something that needs to be considered. So is the person that I'm trying to restrain somebody who is mates with all of the senior staff that are going to stay? Are they going to all be in regular contact with each other? What's the level of influence that person has on my key executives who are going to be staying with the business, or over my clients, or over my key suppliers, or over the rest of my staff? What's the kind of weight or authority that is attributable to the person that I'm seeking to restrain, and the types of impacts that that could have on my business as the person who is seeking to enforce that restraint? Payment is also really important. So am I seeking to restrain somebody for the next 2 years when I'm only going to give them 2 months severance, or notice payout? Is that reasonable? Am I seeking to prevent them from feeding their family or being able to pay the rent, when I'm seeking to restrain them for a period, but I'm not really willing to offer any kind of monetary or financial compensation for them to be sitting on their hands for that length of time? So looking at whether or not I'm preventing somebody from the ability for them to work at all is something that was actually considered in a case which is set out in the accompanying paper, and that's Just Group Limited and PEC. And PEC was a CFO for the Just Group, and the Just Group was trying to prevent or restrain PEC from working for, and they listed 50 different companies. There were all sorts of different things that PEC wasn't allowed to do, and the court held that that wasn't enforceable because the company was actually trying to prevent that person from being able to use her skills for different businesses that may or may not have had any kind of direct competition with the businesses in question. So that wasn't held to be enforceable because it went far beyond what was considered reasonable in the business trying to protect legitimate interests, because it covered too much ground. Okay, so let's have a look at the waterfall, cascade, call it what you like. Here are a couple of examples of what we were talking about as having that different type of optionality that is designed to help a court that may not have the flexibility under the restraint of trade clause under the New South Wales Act, so a court in a different jurisdiction or a jurisdiction outside New South Wales. If I was trying to restrain somebody from doing certain things in a particular area, I was operating across the eastern seaboard, I might have in my cascade of restraint areas these different options. So the first thing that I would be seeking to restrain this person from is from being engaged in activities that are in competition with my business in Australia. Now, that might be because I'm currently operating in the eastern seaboard, but I've got people who are currently out exploring opportunities to build my business out in Perth, South Australia, and the Northern Territory. And so by the time I actually get to the point in which I'm seeking to enforce the restraint, I might actually be operating Australia-wide. But if the court says no, enforcing a restraint across the country is too broad, then it could strike out Australia and then fall to the next level, which is Queensland, New South Wales, and Victoria, because that is seen as the relevant area in which I want somebody to not be competing with my business because of various different reasons. If B was to be struck out as being too broad, then it would just be New South Wales and Victoria. And as you can see, we're sort of working down and getting smaller and smaller geographic regions, so that worst case scenario from my perspective would be that the person is not able to be in competition with my business within a radius of 30 kilometres from the Sydney GPO. A similar type of thinking is applied to each of these types of clauses. So looking at how long the restraint should be enforceable for. So from termination of the agreement until 3 years after that date, or 2 years after that date, or 1 year after that date. Again, looking at that, starting off with the most onerous time period, and then working your way down to something that is considered to be more acceptable from a public policy perspective or protecting my legitimate interests, to be a more reasonable time period. Now, looking at those restraint periods, they're actually quite long for an employment contract. There's very few courts that would be or very, very few decisions that would be willing to enforce a 3-year restraint period unless you were being paid out for a significant amount of that period, because that's a really long time to be sitting on your hands from an employment perspective. It might be considered more reasonable if it's included in a business sale transaction. So I'm handing over millions and millions of dollars to pay for you not to be competing with the business that I've just acquired for a significant value. And I want to make sure that I've got enough runway to take over the business, have it up and running, be comfortable that I'm actually now able to be up to speed and fully operational before there is any risk of you as the vendor starting up in competition with me. So looking at those, we actually need to also still be asking a couple of things. One of them is, are the provisions of the clause specific enough? So if you don't have a geography in your restraint clause, that's probably fatal. If you don't say that I'm restraining you from doing particular things within a particular area, it's usually considered fatal for any kind of restraint clause. But is it specific? So am I providing enough information that somebody is going to be understanding the types of things that they are restrained from, the geography that they are restrained from doing them in, and also the time period they're restrained from doing that for? The other thing is that we need to be careful about how many different combinations there might be using those different clauses and the different waterfalls that might be creating all of those different levels of combination. So here we've got 2 sets of waterfalls that will give, 5, and using the 3 different options. So I could be restrained in Australia for 3 years, or I could be restrained in New South Wales and Victoria for 1 year. But looking at the number of different combinations that are going to be possible from combining or using those different elements of the different waterfalls against each other, or being able to create those different types of tests, even when you're just using that blue pencil test and striking part of it out. Now, a restraint of trade can only seek to protect an existing business. Before we move off cascades. So there are a couple of decisions that talk about the number of different combinations for a restraint of trade clause and the different types of combinations that you could make from those different waterfalls or those different cascading provisions. So in Ostratangs back in 1983, the court held that there was a series of in that case there was a series of cascading options that created something like crazy, like more than 82,000 different combinations from the way that you could combine the different elements of the cascades. And that was held to be unenforceable, because how on earth would you know which of those different combinations might apply or might be enforceable? Having said that, in 2014, there was another decision, which was Bulk Frozen Foods and Excel, which said restraint clauses that did deliver something like 8,000 possible different restraint combinations, that was permissible and that was enforceable. So we have these types of clauses in place to deal with the fact that we've got the blue pencil test, or whatever you'd like to refer to it as. That means that a court can just strike out the part that it doesn't like and the rest of the clause will still be enforceable. But having said that, in New South Wales, we use this type of drafting as well. So it's seeking to provide some greater level of certainty or some greater chance of success for enforceability, so that people understand that there are fallback positions in the event that the preferred position, from the point of view of the person who's seeking to enforce the restraint, does have a number of different options that would be fallback positions if the preferred position is held to be unreasonable. Okay, so looking at the importance of tailoring for particular circumstances. Now, if we're trying to enforce a restraint of trade against somebody who is an entry-level position who might have confidential information, but also may not be able to use it, or really isn't going to attribute a commercial value to the confidential information that they might hold, is less likely to have a restraint enforced against them. When you compare that to somebody who is a very senior employee, who is somebody that holds highly commercially sensitive information, somebody who is the face of the business, who is the client-facing person, who is coordinating all of the client interactions, who is holding that key to some or all of the third parties that could make or break the success of the business going forward. So we need to be asking ourselves, when we're looking at these types of restraints, who is the person that's holding that information? What's the commercial value of that information to somebody else? And how long is that going to hold value for? So somebody who might be in a relatively junior position or less senior position might have some kind of confidential information as to the way that a business operates, but they may not necessarily be in a decision-making role or moving into a decision-making role in which they would be able to use that information or derive some kind of benefit for themselves or from another party, in connection with that information. Somebody who is looking at using that information or inducing somebody to breach a restraint clause is also potentially liable for involvement in a breach of a restraint by the person who is the party that's restrained. So if I am the new employer of a very senior executive and I encourage that person to breach their fiduciary duty, if they have a fiduciary duty, their contractual duties in which there is a restraint clause, or I am the senior employee who has left an organisation, and then I'm actively encouraging and facilitating another employee to leave my erstwhile employer. The person who is encouraging and involved and aiding and abetting is also somebody who can be held liable both for a breach of contract and potentially also their duties under the Corporations Act. So an employee and an officer have obligations not to use information that belongs to a company for the benefit of themselves or somebody else. And they also have a duty not to act in contrary to the interests of that corporation. So looking at that, it's not just a restraint clause in an employment contract that is the only way in which somebody can be restrained from certain activities. And some of those are, here we go, set out here. So where else should we be looking, or should we be conscious as operating either in addition to or instead of a restraint under an employment agreement? One of them a very obvious one would be a business sale agreement. So if I'm acquiring a business, I want to know that that the vendor is not setting up in competition with me as soon as we've completed. Looking at shareholders agreements. Now, when we are considering shareholders agreements, it is very much worthwhile setting out from an enforceability perspective the types of contributions that each shareholder is actually bringing to the existing business. So if my contribution as a shareholder is to be the face of the business and my personal image is being used to promote the business, and I am the person who's talking to all of the clients and suppliers and other third parties on behalf of the business, enforcing or establishing the reasonableness of the restraint is easier to contextualize by saying this is the contribution and the obligations on that shareholder to deliver to the existing business, and this is why they should be restrained from setting up in competition after they leave for a certain period of time. Equity plans are another place where restraints might exist. So I've got key management staff who I'm inviting to participate in the equity of a business, and whether that's profit or any other measure that is put in place or contemplated, or I'm going to issue equity to my senior staff members because I would like them to have some skin in the game because we're preparing for a liquidity event like an IPO or a business trade sale or something like that. I'm handing over that incentive and I'm handing over that asset, but I expect in exchange that whoever acquires those shares is also going to want some kind of restraint to be in place against those senior executives when the time comes for those assets to be sold or liquidated or anything else that might be in mind for that type of event. Now, the commercial basis for these types of restraints is probably easier to explain in the context of why it is that it's reasonable for there to be a restraint. So the commercial rationale is different because there is the idea being that whoever is selling their interest in a business or whoever is attributing value to their ownership of the business should actually be prevented from diminishing that value for everybody else or for the purchaser after they have left for a certain period of time, so that the value that's attributed to that business or that corporation is preserved for whoever is on the receiving end of it. So it doesn't make sense for you as an owner to just be able to take all of that value off the table. You get financial compensation in return, but then you're able to then wipe the value as soon as you walk out the door. So looking at that, the restraint is easier to explain because in that circumstance, there is hopefully for the person receiving it quite a substantial monetary consideration that is actually tied directly to their exit from the business, rather than it being sort of a general employment relationship. There is a key transaction that can have value attributed to it that explains why the restraint is reasonable. Because you can point to assets, you can point to those types of things. So when you've got valuable consideration that's delivered in exchange for a particular time period and a particular geography and particular assets, then it's easier to say, well, I have just given you a whole lot of financial compensation. I expect you to allow me to preserve the business in what I've just paid you for. So let's have a look at how some of those assets are considered. And one of the key assets for consideration is goodwill. So what is goodwill? And this was explored again recently in the federal court's decision in Findex Group and Mackay. And it has an established, the court held that the meaning of goodwill is established and it is wide. So whatever adds value to a business by reason of situation, name, reputation, connection, introduction to old customers, and an agreed absence from competition. So it's the force that brings in your business. It's the custom, it's the revenue driver, it's the thing that distinguishes an established business from one that is just starting from scratch. Now, any business owner is going to want to preserve not just its existing connections to customers, staff, and suppliers, but also its reputation in the market. That's the thing that has value attributable to it. That's the thing that keeps the dollars coming through the door. Now, what is know-how? There are a lot of people who will come to you and say, "Well, this is my IP. This is all my intellectual property." You say, "Well, what is the IP?" And they'll describe essentially a whole range of things that aren't necessarily intellectual property from a legal perspective. That it's not a patent. It's not a trademark. It's not a system that is subject to legal protection in an intellectual property sense, but it is still valuable. So know-how is the secret sauce. It's how we do things around here. It's the reason that makes us really good at what we do. It's the reason that our customers love dealing with us. So that is, that is the type of asset that somebody might be aware of. So I might have confidential information or sensitive information as to how an ordering system works, or how a client relationship management system works, or how I put together my widgets in the best possible way that means that I can do that 20 times in a day rather than 10. It's whatever gives a business a competitive advantage in the market. So that could also extend to client information. I know things about contract terms. I know things about tender processes. I know things about expiry dates. I know things about how people operate their business, how my clients operate, how they need their pricing arrangements to work. These are all of the things that can be recognised as a legitimate protectable interest. And a reasonable restraint can be used to protect the incoming party, so the purchaser of a business, for example, from being commercially disadvantaged from somebody else using that information after whatever the relevant transaction has occurred, or when the employee has left the business that is seeking that protection. So let's have a look at some recent decisions. McMurtry and Employee Insure, and Cameron and Employsure, 2022 decisions. In this case, McMurtry was approaching the employees of a business that he just left. And the court held, this is in New South Wales, so a more friendly jurisdiction for enforceability, but the court held that a 9-month post-employment restraint clause was reasonable and enforceable against a former sales manager who had joined a competitor's business. So sales manager, somebody who is very much the client-facing aspect of a business, but the court did talk about how an employer can only enforce a restraint clause on its employees if the clause is to protect its legitimate interests. And those legitimate interests may only be protected for a reasonable period of time after the employment relationship had terminated. Now, in this case, the nature of the information that was being shared was confidential, and it was likely to create a current and it was likely to hold value for a long time, at least for the 9 months of the restraint, and create a commercial advantage if somebody else was to use it within that restrained period. McMurtry was also approaching current employees to poach them, and played a material role in their decision to leave. So he was held to be breaching his fiduciary duties to promote the company's best interests and his duty of fidelity and good faith to the company. So McMurtry was held to be liable to compensate for the harm that was caused to Employsure as a result of its actions. And the new employer was also found to have knowingly assisted or induced him to breach his fiduciary and contractual duties. So the new employer was held to be an accessory to the harm and also liable for the revenue that was lost. Looking at a federal court decision, AIE Insurance Group and Martin in 2024, Now, the court in that decision was this, and this was a decision in relation to somebody who had left an insurance brokerage firm and gone to a new brokerage firm. And the court was talking about how an employee isn't entitled to be protected against mere competition from a former employee. So an employee is entitled to use their full personal skill, their experience, their qualifications, etc. There's no restriction on a person doing that, but the employer is entitled to be protected against what was described as unfair competition. So the interest that the employer was seeking to protect was its customer connections, because Mr. Martin was using those customer connections and soliciting clients who were then taken to the new brokerage firm, and they attributed the loss of revenue to be about $750,000. Now, it was held that the restraint of trade in this instance was held to be reasonable because he was considered to be the face of the business, and it is likely that his customers attached their connection to the business through him rather than just to the business itself. So the 12-month restraint period was reasonable because insurance books and policies usually have an annual duration, and that period would see clients through to their next term. So when they're assessing damages, the court held that $500,000 was reasonable to settle on, because it needed to take into account that some clients, without him contacting them, would have learned that he had gone to another brokerage, even if he didn't solicit them. That change. So people might have seen that he'd moved somewhere new, and they would follow him without him actually engaging in any problematic conduct. So the court still retains that discretion to determine whether or not the restraint of trade is reasonable, but also looking at the type of compensation that is reasonable, because it's not just a lift and shift. You took this, this many clients followed you, and that was, and that we should get all of that revenue, because there are some clients who would have found out that Mr. Martin had moved, and without any kind of prompting on Mr. Martin's part, would have followed him along for that move. And one of the last decisions that we've got time for is the sign advisory business. So the sign being the business that came out of PwC's government consulting arm. And this decision was really just highlighting the importance of moving quickly. So proceedings should be commenced as soon as possible after the employer becomes aware of the circumstance that include a threatened breach of ongoing obligations. So in considering whether or not there was a serious question to be determined, a 3-month delay in seeking relief wasn't reasonable from the court's perspective, because an employer shouldn't wait until the employment ceases if there is a real and live threat that there will be a breach of the restraint obligations. So if you are aware of that, or if the employer is aware of that, it can't sit on its hands before it takes action. So where to from here? There is legislative reform that is currently proposed. Whether or not that's the right path is yet to be seen. So as we talked about, the government task force is relying on ABS data without necessarily being able to point to evidence that says a restraint clause is bad for competition, or a restraint clause is, or the courts are an inappropriate forum in which to enforce a restraint. There are reasonable and justifiable restraint clauses in a business sale and purchase contract, equity incentive schemes, shareholders agreements. So be aware that there is not just one place to look when you're considering whether or not there might be a restraint in place, and advising somebody who is subject to a restraint, and making sure that you're covering the different elements in which they might, or the different ways in which they might be restrained. And a lot of that will depend on whether they're also an owner of the business as well. Now, context is everything, and if it's possible, an explanation within the document that includes the restraint as to why it's reasonable will be helpful in providing that context to a later consideration of whether or not these are interests that are legitimate and that we're seeking to protect for a really good reason. We've talked about taking care with drafting, particularly where there isn't the flexibility that there is under the Restraint of Trade Act in New South Wales. So looking at geography, looking at the types of activities, looking at the level of seniority of the people and the nature of the role of the person who is sought to be restrained, and trying to make it as straightforward as you can for a court to consider that a restraint is enforceable because it is a reasonable protection of legitimate protectable interests. That brings us to time for questions. And we've got one question that has come up. So it's common for restraints to be waived in exit negotiations. However, are there other ways for an employee to challenge the enforceability of a restraint after they're agreed and at the end of an employment relationship? So yes, a restraint is often waived when the person who has the benefit of the restraint is very keen to see somebody exit. So they're willing to waive the restraints because they just want somebody out the door. We don't care about what you do afterwards, just get out. Now, other ways for an employee to challenge the enforceability of a restraint is really going to come down to you can always agree it. So you can negotiate something that's different, or you can negotiate a full or partial waiver of the restraint, or to challenge it by saying that it's not reasonable or it's not seeking to protect a legitimate interest, saying that you've cast this net so broad that I would never be able to ever earn the things, the take on a role for which I'm qualified, for example. I would never be able to pay my rent if this restraint was enforced. So it's absolutely not reasonable. We've got another question. So what is the relevant time to consider whether a restraint is reasonable? At the time that the contract is signed or the time of the breach? Good question. So the breach is going to be the time at which it's assessed. But having those sorts of things in place and having those considerations at the time that the agreement is entered into is also going to be relevant. But it's really going to turn on when the breach occurs.